So, welcome again to this room for the second part and fourth session of the joint Audit Day event. This session will be dealing with a topic that has been mentioned earlier this morning, which is an important one for audit firms and the legal liability. And we will have three presentations or talks from the regulators that are involved in this event, meaning a representative from CIPOSA in Bulgaria, Mrs. Dariana Kotseva, will make a presentation about the legal framework for liability of the joint auditors. Mr. Jan Tega, who you have seen this morning from IRBA, will also describe the way this important notion of legal liability for the joint auditors is dealt with in South Africa. And Thierry Ramonaxo, who is head of the H3C Enforcement and Investigation Division, to my left, will describe the current situation in France. If I may, I would like to give the floor to Diana. Okay, we can see you. I think there is a presentation.
To share my presentation now. It's okay. Is it visible, my presentation?
No, not yet.
Okay, try. Okay. Now is it visible?
Yes, it is. Thank you.
Okay. Good afternoon. I will start my presentation with the legal framework of joint audits in Bulgaria. The legal framework of joint audits in Bulgaria is covered by several legislative acts. The first legislative act is the Independent Financial Audit Act, and it is stipulated in that law that the registered auditor shall be held financially liable for the damages caused by the registered auditor by him if these damages are the direct consequence of his wrongful act or omission. The Independent Financial Audit Act explicitly states where the financial audit has been jointly performed by more than one registered auditor. Registered auditors' financial liability shall be joint and several. Also, it says that registered auditor's liability to the planned entity shall be limited to the triple amount of the insurance fee for the registered auditor professional indemnity insurance, but not falling, however, below the amount specified in that law concerning this professional indemnity insurance, concerning the amount for one single insurance event. Limitation of liability shall not apply in the case of intentional misconduct by the registered auditor, including where the client entity is being declared bankrupt. It also said that when there is a disagreement, each registered auditor shall submit his or her opinion in a separate paragraph of the audit report and shall state the reason for that disagreement. The other law which explicitly covers the Joint Audit Act is the Credit Institution Law, and it actually states that the banks, there is an obligatory requirement for banks to have their annual financial statements audited by jointly by two audit companies. It says that the annual financial statement of each bank of individual and consolidated basis are subject to independent financial audit jointly by two audit firms that are registered auditors under the Independent Financial Audit Act. Actually, each bank in Bulgaria shall agree in advance with the Bulgarian National Bank the selection of auditors. The Bulgarian National Bank has to approve this to the joint auditors. And the Bulgarian National Bank, in agreement with the Commission for Public Oversight of Registered Auditors, adopts criteria for coordination of that selection. Also, the insurance code in Bulgaria declares that the annual financial statements of an insurer, respectively a reinsurer, an insurance holding company, and a financial holding company with mixed activity with registered office in the Republic of Bulgaria, also are subject to joint audit reports. Also, the same requirement stays for the pension insurance companies. In the social insurance code is stipulated that the annual financial statements of the pension insurance company and of the pension funds managed by it are certified jointly by two audit companies. In Bulgaria, there are guidelines which have been developed and adopted by the Commission for Public Oversight of Statutory Auditors in coordination together with the Institute of Certified Public Accountants. And these guidelines are one main document which define the role and the responsibility for joint auditors. First, they define that the auditor's roles and liability is joint and several, they're equally liable. No matter what the division in their work, they are held equally liable. There are no limitations for liability due to negligence or poor quality of the other joint auditors' work. Also, the guidelines envisage full cooperation and joint endeavor by both joint auditors. They are obliged to express a single audit opinion. Also, the guidelines cover the topic when there are cases of disagreements, when there is a contentious matter and it cannot be resolved by the joint auditors. The responsible auditor shall document this in the audit file, the disagreement on the matters, which was significant to the audit areas of judgment, as well also the grounds. And the document should contain the following information. It should contain the description of the contentious matter, the applicable auditing standards, the proposed resolution of the issue, and information of the actions undertaken to resolve the issue. Each auditor is obliged to make necessary efforts to resolve this difference with the other joint auditor prior to the issuance of the auditor's report. In these rare cases, when they cannot solve the problem, when there is no agreement, then they have to modify their auditor's opinion, and there should be a paragraph. Included in the opinion included in the audit report. They should state the reason for their disagreement. As I said, there are joint criteria and procedure for coordination of the selection of bank and insurance companies auditors. And speaking about the criteria for auditors of banks, the Bulgarian National Bank, in coordination with the Commission for Public Oversight of Statutory Auditors, has adopted such criteria and procedure for coordination of the selection of bank auditors. And there are two main criteria. First, there are strong professional qualification criteria. And second, there is a criteria which is related to lack of conflict of interest and good reputation. It's forbidden that the auditor if he has some material interest in a bank, or if he's in the governing body or is an administrator, it's not allowed for him to be a part of the joint audit. The same criteria apply for auditors of insurance companies. Also, again, they're related with their professional qualification and lack of conflict of interest and good reputation. Talking about the liability, we can talk from two different points of view. First is the civil liability for joint auditors, which is covered generally by their professional indemnity insurance, and secondly, it's their administrative pecuniary liability. Generally, the legal liability of the auditor covers all obligations for compensation of damages, both those that are caused to the audited entity due to non-performance of contractual obligations, and also those that are direct and immediate consequence of breach of general legal obligation of the registered auditor. If the auditor doesn't perform strictly the audit engagement, it doesn't perform it well in accordance with the auditing standards, and this results in direct and immediate damage to the audited entity with which the auditor is a contractual relationship. It's clearly a contractual liability, and it's governed by the Bulgarian law on obligation and contracts, speaking about the consequences of non-compliance. Also, third party may also claim damages on tortious grounds, for example, failure to maintain professional secrecy. The auditor's liability is limited and personal, but only if it's contractual and unintentional. Only if it's based on negligence. Then it's limited to 3 times the amount of the agreed remuneration, which may not be less than the amount specified in the law for one insurance event. Full liability, it could be also full liability, and full liability arises when his or her intentional actions have contributed to the insolvency of the entity. The responsibility of the auditor is based on guilt. It is the responsibility of guilty action or inaction. Solidarity is present in both contractual and tort liability. The liability is governed by the rules of law on obligation and contracts, as I said, and it's carried out according to the general claims procedure. Liability could be waived if the violations are directly related to the actions of the management, as well as for the detection of fraud. The burden of proof falls on the audited entity, which claims compensation for damages caused by the auditor's wrongful and culpable acts and omissions. It must prove that the auditor has violated its obligations under the law and the contract, that damages have occurred, specify their amount, and prove the causal link between the auditor's conduct and the damages. guilt is assumed, and if the audited entity claims full liability, it should demonstrate that the auditor's actions were intentional. The auditor must prove that he is not at fault, that he has done everything possible and necessary to anticipate and prevent the damage. He must be insured for liability for damages resulting from culpable failure to fulfill obligations. As I said, this professional liability insurance is mandatory. Talking about the administrative pecuniary liability, when the inspection is performing its when the Commission for Public Oversight of Statutory Auditors is carrying out its inspections and finds out that an auditor has committed an administrative offense, when we're talking about joint audits, it's actually the situation where a notice establishing administrative offense could be issued to both auditors when we have a situation with joint audit. This is the principle. Basically, I covered the subjects. Thank you very much for your attention.
Thank you very much, Tariana. Thierry, the floor is yours.
Thank you, Patrick. Well, I'm really delighted to participate, to attend this meeting. It gives me the opportunity to share with you my recent experience drawn from past enforcement cases or past enforcement, not only enforcement, but investigation cases. I try to share with you my personal insight about the implementations of the NEP. It is French auditing standard, the NEP 100, concerning the joint audit. But just to clarify this last point about investigations, when I am talking about investigation, I mean some different points that we have identified as potential violation of this particular or specific legal provisions. But it doesn't mean that these facts have been always eventually sanctioned. I think it's important to underline this point at this stage of my presentations. Just one point. We know that disciplinary investigation are always considered by audit firms and partners like a very serious matter regarding the consequence about the reputation of the audit firms, and we take into care of this too. And I just mentioned that since the beginning of the investigations department, we have conducted over 200 cases or investigations finalized by a report, and on these 200 cases we dealt with only 30% have been sued and finally sanctioned. Well, due to the time limits, I will start my presentation immediately. So I think it's not useful to come back about the legal standpoint and to remind you the contents of the French article of the French Commercial Code 823.15 because I think its point has been dealt with this morning. I just want to underline 2 points that seems to me very important to highlight. The first one is that the joint audit enables to put in place a common purpose between the auditors, and it gives the opportunity to have an extra set of eyes. I think it's very important to ensure and to maintain a high level of professional skepticism and independence. And the other point I would like to underline is strengthening of the position of the auditor vis-à-vis the audited entity. What is this point? I think that in some circumstances, we have detected that in some circumstances, and for instance, if a financial management of audited entity try to prevail its point of view against a single auditor about a controversial accounting treatments not compliant with accounting rules, two auditors, it's my point of view, I'm sure that you will be able to share this point with me. Two auditors should both withstand it better and deliver a stronger opinion on financial statement. I think that we can apply to these situations and hold adage, united we stand, divided we fall. I think it's a good illustration of this principle. The other point I would like to underline at this step of my presentation is concerning the HTRC guidance for one of the major topics. It is one of the major topics. Another point is very important, according to me, is the distribution of tasks between joint auditors, which must be balanced, not equal. It's not equal, it's not 50-50, but just balanced. And in some circumstances, in some cases, we met some situations in which there is no balance between the auditors. We have faced a situation with a number of audit hours is very unbalanced, and it's raised a difficulty, a problem, because the consequence is that it's an inability to support the opinion and the violation of auditing standards. This point seems to me very important. The other one is what is the cruise review? What is behind the cruise review, in fact? I just want to remind at these steps the main principle of cruise review, and they are the following ones. Joint auditors are jointly liable for the audit performed, and each auditor conducts a review of the work performed by the other auditors. I think that just a reminder, of course, this review allows an auditor A to assess the audit work carried out by an auditor B and vice versa. And the assessment comprises, and just a reminder, assessment of the conformity to the work plan defined in the national registrations, assessment if sufficient and appropriate audit evidence have been collected, and assessment if relevant and coherent conclusions have been drawn. Now, comment on revient? J'étais trop vite, c'est pas grave. Now, I would like to say a few words about issues identified during investigation concerning implementation of the NEP 100. From past investigation cases, we spotted some particular issues that could be representative of an incorrect re-implementation of joint audit violating auditing standards. The first one is the question of consultation on the work program. In some cases, we detected that this consultation on the work program has not been insufficiently implemented or not implemented by the joint auditors. It's a very relevant and crucial point. I just want to remind that such items, as described on the slide behind me, such items are being identified in some cases, and these cases have been mainly reported by inspection reports at the origin of the referral of the Enforcement Investigation Division. But we are not only sized by the inspection control inspection division, of course, and we have in the other case with the different sources of referral coming from external or different authority. The second point is a joint auditor A perform an insufficient cross-review of the work performed by joint auditor B, and it's the most common case we met during investigation. It's one of the potential most important case. So I think it's this insufficient cross-review can be materialized by a series of criteria or series of facts. I give you just some example. Lack of thorough cross-review by A lack of professional skepticism by A on the nature and scope of work carried out by B, insufficient documentation as a cross review. I think that we should not lose sight of the main issue. Joint Auditor A must demonstrate in his audit files that the nature and extent of the work carried out by Joint Auditor B is sufficient and appropriate to obtain a high level of assurance as the absence of material misstatements in the significant accounts audited by the Joint Auditor B. And to conclude, because the time is quite lapsed, concerning the concluding remarks, I will just mention that those investigation cases are probably not representative of the ongoing implementation of joint audit in France, which is highly effectively in the most cases. I just remind the number of cases open and the number of cases final issue by the HRC, and you can see and verify, check this point. We make sure, in fact, I think that the most important maybe could be, it's my point of view, to make sure that joint auditors are able to keep efficiency and professional skepticism. And we have to take care of different points. These different points are, according to me, the following ones. Hold good working partnerships and a high level of communication. It's very important. It's crucial. It must be ensured, the other point, it must be ensured that joint auditors have the skills to audit certain audit cycles, IT audit, for instance, review of internal control, financial instruments. So I think that a joint audit is respecting both those requirements and also provision of auditing standards, including the NEP 100, is a factor in securing the quality of the opinion issued. Thank you very much.
Thank you, Thierry. Jan, could you please provide us comments regarding the application of liability to auditors, to joint auditors in South Africa when deficiencies are observed by the regulator?
Yes, thank you, Patrick. Good afternoon to all the attendees and participants of this event. So due to the time limits, I'll also start with my conclusion and then I'll work backwards and see how much we can get through it. So in essence, within the South African jurisdiction, we don't have separate legal requirements for joint auditors. Therefore, the normal legal provisions in our Act will prevail. So our Act is called the Auditing Profession Act. There's a particular section in there that deals with the legal liability of an auditor in general, which is section 46. But in essence, if we apply it to joint auditors, the conclusion is that each joint auditor is independently liable towards the client and or third parties, right? Practically, because we've got joint auditors, what that means is that the joint auditors are jointly and severally liable, right? Then you move back and you go into the Act itself in terms of what the Act says. So there could be various reasons why the joint auditor could be liable. An auditor can attract criminal liability due to the contravention of the various sections of the Auditing Profession Act, or they can attract civil liability towards the client or third parties. The auditor attracts civil liability towards the client for failing to comply with the statutory duty of care and skill towards the client, so in other words, not doing the job correctly, or for breaching the terms and conditions of the agreement that the auditor has with the client. The auditor can also attract civil liability towards third parties due to having acted, for example, negligently, which my colleague earlier spoke to, in providing a clean audit report when it should have been qualified, or where the third party relied on the auditor's negligent misstatement, and the third party suffered a loss as a result thereof. So that's literally the ambit of how the legal liability applies in the joint audit scenario. With respect to how we regulate it from a regulatory perspective, because these are joint auditors, what our inspections department does is we issue an inspection findings to the joint auditors in duplicate. So the same inspection finding is done twice and sent out to our joint auditors, and we expect them to respond jointly as well in terms of responding to the inspection findings. And how we take it forward as the IRBA, the Independent Regulatory Board for Auditors, is we will then decide how we take it further, whether we take, we sanction the joint auditors together or individually, or the partners for each for the who perform this particular engagement. So the sanctioning happens on different depending on the matters of the case. But the operational matter is that the inspection findings is sent to both to all the joint auditors, and all of them are sent the same inspection findings, and we expect them to respond to the inspection findings together as the joint auditors who are responsible for the joint audit engagement. Patrick, if I've got some time, I'll speak a bit more, but I'll hand over back to you now, please. Thank you.
Thank you very much, Jan, and it was very clear. Unfortunately, we're running out of time. Therefore, I will just ask if there are questions in the room. Okay. Well, thank you very much, Jan. Thank you, Diana, for this presentation. Thank you, Thierry, also. And we will close this session of the event and move on to